Hey there, welcome back to our channel. We've got a great video for you today. Have you ever wondered about all those federal employment laws out there? What do they cover? How do they impact your business? Today, we're diving into the essential federal employment laws every U.S. employer should know. And stick around because we'll be sharing resources to help you stay in the know. Now, let's dive into these crucial federal laws. The first on our list is the Fair Labor Standards Act, or FLSA. This law covers aspects like minimum wage, overtime pay, and child labor restrictions. Remember that all employees covered by the FLSA must be paid a minimum wage, which, as of February 2024, is $7.25 per hour. Plus, non-exempt employees are entitled to overtime pay at a rate of time and a half if they work over 40 hours in a workweek. The FLSA also has specific rules regarding the employment of minors in various industries. By adhering to the provisions of the Fair Labor Standards Act, employers ensure fair treatment of their workforce, while avoiding potential fines and penalties. Next up is Title VII of the Civil Rights Act. This landmark legislation prohibits discrimination and harassment in the workplace based on race, color, religion, sex, including pregnancy and gender identity, and national origin. Title VII covers all aspects of employment, including hiring, firing, promotions, pay raises, and training. It's important for employers to provide reasonable religious accommodations to employees and to take steps to prevent and address harassment. The third on our list is the Americans with Disabilities Act, or ADEA. The ADEA prohibits discrimination against qualified individuals with disabilities and requires employers to provide reasonable accommodations to enable them to participate in the workforce. Reasonable accommodations may include flexible work schedules, assistive technology, or modified job duties. However, employers are not required to provide accommodations that would impose an undue hardship on the business. Coming in at No. 4 is the Pregnant Workers Fairness Act, or PWFA. This relatively new law, which took effect in June 2023, requires employers to provide reasonable accommodations for employees who are pregnant, have recently given birth, or are experiencing related conditions. Similar to the ADA, the PWFA prohibits discrimination against pregnant workers and requires employers to treat them as they would any other employee with a temporary disability. One important aspect of the PWFA is that employers cannot force employees to take time off when they are still able to work, and they cannot deny light duty or alternative assignments. At No. 5, we have the Age Discrimination in Employment Act, or ADEA. The ADEA protects workers who are 40 years of age or older from discrimination in hiring, promotion, and termination. It's important to note that the ADEA does not apply to all employers. However, once an organization reaches 20 or more employees, the ADEA's protections kick in. Next up is the Genetic Information Non-Discrimination Act, or GINA. GINA prohibits employers from using genetic information to make decisions regarding an employee's eligibility for life insurance, disability insurance, or health insurance. It also prevents employers from discriminating against employees based on their genetic information. In at No. 7 is the Family and Medical Leave Act, or FMLA allows eligible employees to take up to 12 weeks of unpaid leave per year for specific family and medical reasons, including the employee's own serious health condition, the birth or adoption of a child, or to care for a spouse, child, or parent with a serious health condition. It's crucial for employers to understand the eligibility, requirements, and documentation processes associated with FMLA. Coming in at number 8 is USERRA, the Uniformed Services Employment and Reemployment Rights Act. USERRA protects the employment rights of service members and veterans. It ensures that service members are reemployed in their civilian jobs upon their return from deployment and that they are not discriminated against due to their military service. USERRA also requires employers to provide certain information to service members and to comply with specific procedures regarding their reemployment. Next on our list is the Equal Pay Act. The Equal Pay Act requires employers to pay men and women equally for performing substantially equal work. Employers must be able to justify any pay differences based on factors such as a seniority system, a merit pay system, a quality or quantity of production, or a bona fide occupational qualification. In at number 10 is the National Labor Relations Act, also known as the NLRA or Wagner Act. The NLRA protects the rights of employees to organize and collectively bargain. It allows employees to form, join, or assist labor unions, and to engage in collective bargaining activities. The NLRA also prohibits employers from engaging in unfair labor practices, such as interfering with employees' union activities. At number 11 is OSHA, the Occupational Safety and Health Act. OSHA's primary goal is to ensure safe and healthy working conditions for employees. Employers must comply with safety standards, provide a risk-free work environment, and offer training to employees to help them recognize and avoid workplace hazards. And last but certainly not least, is the Immigration Reform and Control Act, also known as IRCA. So there, you have it. A quick overview of the essential federal employment laws for U.S. employers. Staying informed about these laws is crucial for creating a compliant and respectful work environment. If you want to go deeper into each of these laws, we've got you covered. Check out the link below where you can learn more about each of these laws and how they impact your business. And remember, knowledge is power. So invest in understanding these federal employment laws and empower yourself to create a better workplace for everyone.